Hello, I'm Natalia Angelini.
And I'm Domratchev.
Welcome to Helen Estates. We are going to be discussing an interesting case today coming out of the British Columbia Court of Appeal. It is called Bergler and Odenthal, and we will have it posted on our website.
Yes, it's an interesting case. It's actually about secret trusts. And I thought that before we get into the facts a little bit, we can talk about, what secret trusts are. I think that mostly the elements of a secret trust are applicable in British Columbia, just as they are here. So I think this case is quite relevant. So generally, in order to prove a secret trust, you have to show an intent by the testator to subject the trustee to an obligation in favor of a beneficiary. You have to show the communication of that intent to the trustee took place. You have to show acceptance of the obligation by the trustee, either expressly or implicitly. And the conditions have to be satisfied before or after execution of the will, but definitely before the testator dies.
And it's interesting because in these kinds of cases, there's often no documentary evidence. It's oral testimony about these communications. And it's interesting to see the commentary from some well-known academics in our area that indicate that, even if the person doesn't expressly confirm acceptance, their silence can speak for itself. They have that positive obligation to object if they don't accept the secret trust obligation.
Yeah, that's what makes this case interesting, because it actually deals with something like that. And importantly, though, one of the things that you have to do if you're trying to prove a secret trust is there has to be corroboration under Section 13 of the Evidence Act. So you can't just show up and say there's a secret trust for my benefit and the trustee of this trust has breached their fiduciary duties. You actually have to bring in some sort of independent evidence to support your allegations.
Right. So it's not an easy claim to put forward, and we don't see them being put forward that frequently. And so that's why this is actually an interesting one that we've actually got a court decision on. So maybe let's get into the facts a little bit.
Right. So this is a fairly recent decision. It's a 2020 decision of the British Columbia Court of Appeal. And basically it surrounds around a secret trust allegedly imposed by the testator, Angelica Stuff, I think you pronounce her last name, the deceased, on her common law partner, the defendant in this case, Mr. Odenthal, and allegedly, according to him, accepted by him. And so the trial judge actually accepted that there was a secret trust, which is why we wanted to go over this today, because it doesn't happen very often. The trial judge accepted that the common law spouse in this case had an obligation to ensure that the estate would go to the plaintiff, the deceased's niece. So there were actually two nieces. One of the nieces, I think it was accepted by most of the parties involved that she was not well provided for, both professionally in terms of housing and work, and she intended to go back to school. And so the corroboration in this case of the obligation came from another niece of the deceased and the deceased sister. So they both said that there was a secret trust in place. Initially, this application was actually commenced by two of the nieces, and then, the one niece who corroborated the evidence here dropped her claim fairly quickly, as it was really about the niece that, was not well provided for.
Right, but it certainly was clear, and I think there was no dispute that there were discussions happening.
Yes.
That the deceased was having with the defendant to the effect of, when I die, I want you to hold my estate property for my niece, and I want you to give it to her if and when you start a new relationship.
There was a question in terms of timing, both.
Right.
There was when he started the new relationship, or was it when he
died?
And so the issue was really that the deceased had no will. She was in the hospital, and I don't think there was a disputed fact that she was, it was suggested to her that perhaps a will should be made, but she wasn't well enough to do it, and then she died. And so on intestacy, her common law spouse inherited the entire estate. His evidence of timing was, it seems that he accepted the fact that he accepted this obligation based both on his conduct before the litigation and throughout the litigation. So at first he said there was an issue of time. At first he said, I was supposed to just enjoy it for myself, and then I would leave it for everyone else. And in support of that, he actually said, well, I did up a will, and a certain portion of my estate was to go to her family, and it would represent approximately the amount of her estate, which was worth, I think, about $130,000.
Right.
But then he also said there was some assertion that perhaps he was to have the estate, but then he was only to give it to the niece when he entered a new relationship. And so there was this issue of timing, but then of course he did enter into a new relationship. He even married someone else. And so that's what made the judge's finding so much easier, because he actually married someone else. And so in the course of litigation, he seemed to accept this obligation. He just kept arguing that he wasn't going to give it to them right away.
Right, but it was clear in his evidence that he knew he had this obligation. And I think it was unfortunate that once the litigation started, he then proceeded to revoke his will that he had made to favor the niece, and basically was ignoring and admitted that he was not following through with the obligation imposed upon him. So the outcome, given these specific facts, don't totally surprise me that the court found there was a secret trust and you have the obligation and he's now got to follow through.
That's what makes it easier. The fact that he's essentially admitted to the most difficult aspect of it realistically. Well, I mean, maybe the most difficult aspect would be proving that there were any discussions to start. But I think that if he had not accepted the obligation so easily, this would have been decided maybe differently.
And he did appeal because he was really taking issue with that component of the test in terms of his acceptance, right, of the obligation, and the court just wasn't having that. So the Court of Appeal found no, there were no errors, and upheld the Court of First Instance's decision. So it's definitely an interesting case, a really sad situation, because it is kind of a commentary or a reminder that it is so much more helpful, or it can be so much more helpful, to have your estate plan in place. Because I think in this situation, she became ill unexpectedly and passed probably much more quickly than was expected. So she just didn't even have the opportunity to get things in order. She was not so young, in her early 60s, but younger than expected. So it's a reminder to all of us to get our affairs in order.
I think so.
Of course, people now during COVID, I think everyone's got that reminder.
For sure. Another, I think, interesting aspect of the appeal is that he was self-represented during the trial, and then he retained counsel for the purpose of the appeal. And basically their argument was that the opposing side, i.e. the plaintiff here, had to show that he clearly accepted the obligation to be trustee of the secret trust, and that they had not done so. I mean, leaving aside the fact that he basically admitted to having the obligation, I mean, leaving that whole thing aside, interesting commentary was then made that it doesn't have to be an express acceptance on his part. So to the extent that the other niece and the sister of the deceased corroborated that, yes, these discussions took place. Yes, she asked him to get this estate to the niece. All of that happened. He silently accepted it, didn't say anything.
Yeah.
I mean, that's on him. And so he basically had to say, no, I do not accept this obligation in this particular set of circumstances.
Right.
So the appeal, there was another ground of appeal, but it was just specific to a property. So I don't think we're going to get into that one so much, because it's not, has nothing to do with the secret trust aspect. But
to this point, I liked the reference that the court made to Donovan Waters' observation that acceptance can be spelled out of the silence of the devisee/trustee. And also the comment of Albert Oosterhoff, who said that it was Oosterhoff and Robert Chambers and Mitchell McKines in Oosterhoff on Trusts, and they observed that positive acceptance obviously will suffice, but so too will silent acquiescence.
It's unusual, I think. It's usually that you will want something more concrete. So that's important to consider. So if you're ever in a situation and somebody's like, I want you to give my estate to XYZ, and then you just like look at them and walk away, you might be in a world of trouble.
I know. That is what's really interesting about this. I think we're always thinking about, it's got to be documented. It's got to be documented for this obligation to arise, or at least I think most lay people would think that. Yeah. So it's interesting how quickly you could be held to have this obligation.
I think it's just the circumstances of the case and the way that they worked out. Had he not accepted the obligation before the litigation, had he not taken positive steps like doing up a will, which suggests that, you know, he felt there was an obligation regardless of the time. If there was no corroboration, this might not have made a difference. So, I mean, if there's no corroboration, this might not have worked. It's just that it's kind of like it's stacked in, not in his favor at the end of the day. And the silent agreement bit really was sort of the nail in the coffin on this particular.
Which is unusual, because usually these conversations are happening in private and there are no other people that you're conversing with. And that's not what happened here. There were other people that information was relayed to. So that is unique in this case. And fortunately for Denise, the intended beneficiary. So
yeah. I guess one thing that I found interesting was that this overall estate doesn't seem to, I mean, this is a new case, so 2020, and the estate is worth about $130,000. They went all the way to the Court of Appeal. I wonder if they really gained much at the end of the day. They might have been going to court at the end of the day on costs.
Yeah, I know, which surely would have eclipsed a huge amount of what was at issue.
That's the thing.
It's always something we struggle with and our clients struggle with, is that balancing principles of proceeding and justice versus the cost of justice.
Food for thought, for sure.
Yeah. Okay, Kira, well, unless you have any other thoughts, I think that ends our podcast for today.
I think it does.
Well, thank you everyone for listening and viewing. If you do have any questions or comments, please email us at webmaster@hollandhull.com or leave a comment on our blog. I'm Natalia Angelini.
And I'm Kira Domratchev.
Until next time, so long.